The defense team for David Anthony Burke has been saying for months that there is nothing substantial tying their client to the death of Celeste Rivas Hernandez. That claim has just been overturned with the discovery of the weapon prosecutors say was used against Celeste. But it doesn't end there, because right now, the charges David now faces are some of the heaviest a California district attorney can bring, and the death penalty is sitting on the table. This whole case began on September 8, 2025, at a Hollywood tow yard in Los Angeles. Employees there had been reporting a strange smell coming from one of the vehicles on the lot, a 2023 Tesla Model Y that had been brought in 3 days earlier from the Hollywood Hills. When investigators opened the front trunk of that Tesla, they found the remains of a 14-year-old girl. It would take another week before the medical examiner confirmed her identity. Her name was Celeste Rivas Hernandez. She had been reported missing by her family in Lake Elsinore, California, more than a year earlier, and the Tesla she was found inside was registered to the singer known publicly as David. For the next 7 months, the case moved slowly in public. Behind the scenes, investigators were building something, but to the outside world, very little appeared to be happening. Then, on April 16, 2026, a heavily armed LAPD team surrounded a Hollywood Hills residence and arrested David Anthony Burke. 4 days later, on Monday, April 20, Los Angeles County District Attorney Nathan Hochman held a press conference and announced the formal charges: first-degree murder, continuous sexual abuse of a child under the age of 14, unlawful mutilation of human remains, 3 separate special circumstances attached to the murder count, and one more allegation that almost no mainstream outlet has bothered to unpack properly. That allegation is a weapon enhancement. Inside the criminal complaint filed on April 20, prosecutors included a specific legal phrase that officially names the weapon they believe was used. The exact language in the complaint reads, "a deadly and dangerous weapon, to wit, sharp instrument." That is not random wording.
Today I am announcing the charges against David Anthony Burke, the musician known as David, spelled D4vd, in connection with the brutal and horrific murder of Celeste, a 14-year-old at that time. These charges include the most serious charges that a DA's office can bring. That is first-degree murder with special circumstances. The special circumstances being lying in wait, committing this crime for financial gain, or murdering a witness in an investigation. These special circumstances carry with it, along with the first-degree murder charge, a maximum sentence of life without the possibility of parole or the death penalty. The determination on whether or not the district attorney's office will seek the death penalty will be made at a later time. Before I get into the actual charges, and there are additional charges against Mr. Burke, including continuous sexual acts, lewd and lascivious sexual acts with an individual under 14 years old, and mutilating a human remains of a body. Before I get into the description of these charges and their seriousness, I want to look at this as a parent. I am a parent of 3 children, and a parent's nightmare is a situation where your daughter goes out one night and never comes back.
Under California Penal Code Section 12022, when a prosecutor wants to add a weapon enhancement to a murder charge, they have to publicly commit to what type of weapon they are alleging was used. They cannot leave it vague. The fact that Hochman's office chose the words "sharp instrument" and placed that phrase directly into the charging document means 2 things. First, it adds mandatory prison time on top of whatever sentence the underlying murder charge carries. Second, it tells everyone, the defense, the jury, and the public, that the prosecution believes it can prove in court what category of weapon was used. At the press conference, Hochman went a step further. He told the reporters in the room that his office has physical evidence, forensic evidence, and digital evidence that it intends to present at trial. He did not show the items, he did not list them, but he committed, in front of cameras, to the existence of a physical evidence package tied to the killing. This is the part of the case that changed on April 20.
There is physical evidence and there is forensic and digital evidence that we intend to present in court to prove these charges beyond a reasonable doubt. So with respect to the actual details of the evidence we're going to be presenting in court, I'm not going to do that today. As far as the concept of a smoking gun, the smoking gun is the totality of the evidence that we're going to bring to prove any case, whether it's this case or any case, beyond a reasonable doubt.
For 7 months, the question of what weapon was used has been nothing but speculation online. Was it a knife? Was it the chainsaw that private investigators found at the rental home? Was it something else entirely? After April 20, that question has a formal answer in the court record, and the young man who now has to explain the evidence behind that answer is the same young man who was performing on the Coachella main stage exactly 1 year ago. The charging documents also lock in 2 specific dates. Prosecutors allege Celeste was last seen alive on April 23, 2025. They allege her remains were further harmed on or around May 5, 2025, about 12 days later. During the gap between those 2 dates, David Burke released his debut album, gave press interviews, and began preparing for a world tour that would launch 4 months later. Just before we go any deeper into this, I want to take a moment to thank you for being here, not just for your support of this channel, but for caring about the truth, and for a young girl who is no longer here to speak for herself. This channel exists to cover cases like this one the way they deserve, with verified facts, careful reporting, and no noise. If that is what you want more of, please like this video, share it with someone who has been following this story, and hit subscribe so the next update finds you when it drops. One question before we continue. Do you think the second suspect in this case is someone close to David? Drop your answer in the comments. I read every single one. The death penalty language in the title of this video is not for dramatic effect. In California law, David Burke is now one of a very small group of defendants in the state who is facing a charge that can legally end with execution. But how that actually happens and whether it actually happens depends on 3 different layers that most of the coverage has collapsed into a single line. The first layer is the special circumstances. California does not send people to death row on first-degree murder on its own. Prosecutors have to allege and then prove at least one specific aggravating factor listed under Penal Code Section 190.2. In David's case, they attached 3. The first is lying in wait. Hochman argues that on April 23, 2025, David invited Celeste to his rented Hollywood Hills home under false pretenses, hid his intent, and acted from a position of concealment. Lying in wait is different from simply planning ahead. It requires the prosecution to show a watchful, purposeful state of hiding right before the act itself. The second special circumstance is murder for financial gain. This one is the most unusual of the 3, and it is the one defense lawyers across Los Angeles are paying the closest attention to. The financial gain circumstance is normally used in contract killings, life insurance fraud, or inheritance schemes. Hochman is using it in a much newer way. He is arguing that what David was protecting was his music career itself. The Withered album was 2 days away from releasing. The Wither Out tour pre-sale had launched the same day Celeste arrived at the house. Hochman's theory is that Celeste was threatening to expose the relationship, and that exposure would have destroyed a career worth millions in touring revenue, streaming royalties, label advances, and endorsement deals. The prosecution is asking a jury to treat the career itself as the financial asset being protected. Legal analysts will argue about whether that framing survives appeal, but as of right now, it is sitting on the charge sheet. The third layer is the policy layer. California has had a formal moratorium on executions since March 2019, when Governor Gavin Newsom signed it. That moratorium is still in place today. What it means in practice is that no prisoner on California's death row will actually be executed while Newsom remains in office. But the moratorium only pauses executions. It does not pause sentences. Juries can still return a death verdict, judges can still impose one, prisoners can still be sent to death row. They simply cannot be put to death while the moratorium is active. The third layer is the prosecutor's own policy. In March 2025, Hochman formally brought the death penalty back as a sentencing option in Los Angeles County, reversing the blanket no death penalty policy that George Gascon had previously enforced. But Hochman said publicly that his office would only pursue execution in rare cases, specifically naming school shootings, terror attacks, and the killing of a police officer as examples of what would qualify. The David Burke case does not fit any of those examples on its face, but Hochman's own framework requires every death-eligible case to be reviewed by what his office calls the Special Circumstances Committee, a panel that hears from the defense, takes input from the victim's family, and decides whether the death penalty will actually be sought. That committee review has not happened yet. Hochman said on Monday that the decision would come at a later time. And while the public is watching what comes next from the prosecution, there are 4 pieces of this case that most of the mainstream coverage has either brushed past or missed entirely. Any one of them could change the direction this case takes. The first piece is the second suspect. LAPD confirmed in late 2025 that they had identified a second person who was present before, during, and after Celeste's death. That identification came from a combination of cell phone location data, Tesla telemetry, and geolocation information pulled from social media activity. The second suspect has not been publicly named. They have not been charged, but their existence is on the record with the investigating agency. TMZ founder Harvey Levin, who has covered this case more aggressively than almost any other outlet, described the trip David took to a remote area of Santa Barbara County as, in his words, the key to this case. The working theory that investigators have shared with reporters is that the second suspect did not actually kill Celeste. They may have helped with what happened to her remains afterward. That means prosecutors filed first-degree murder on David on April 20, 2025, while knowing another person is implicated in what happened after the killing. Why David was charged alone, and whether the second person is cooperating with investigators, being looked at separately, or being held in reserve as a witness, is a question the court record has not yet answered. The third piece is Santa Barbara itself. LAPD confirmed in late 2025 that David traveled to a remote area of Santa Barbara County during spring 2025. The trip was reportedly in the middle of the night. The reason for it has not been publicly disclosed. The department's official position is that they have drawn no conclusions about whether the trip matters to the case. But the mutilation date in the charging documents, on or around May 5, 2025, falls about 12 days after prosecutors say Celeste was last seen alive. Any theory that links those 12 days to a late-night trip to a remote part of Santa Barbara County is, at this stage, speculation, but it is speculation that has been on the investigators' timeline since the earliest weeks of this case. The third piece is procedural, and it is the one that legal analysts have flagged as the most unusual part of this entire case. From November 2025 through April 2026, a Los Angeles County grand jury was hearing evidence against David. Deputy District Attorney Beth Silverman, one of the office's most experienced high-profile prosecutors, was presenting witnesses for roughly 5 months. David's day-to-day manager testified for several days. His close friend was arrested in Montana after failing to appear and was brought back to California to give testimony. His own parents and brother were subpoenaed, fought the subpoenas in a Texas court, and lost. That kind of grand jury presentation is almost always designed to produce an indictment. An indictment handed down by a grand jury is procedurally stronger than a complaint filed by a prosecutor acting alone, because it represents a panel of citizens deciding there is enough evidence to move forward. And yet, after 5 months of testimony, prosecutors did not file an indictment. They filed a criminal complaint. CNN flagged this as unusual. The court record does not explain why. The defense has already formally requested the grand jury transcripts, and if a judge orders those released, they are likely to reshape what the public understands about how strong the prosecution's evidence really is. The fourth piece is the Tesla itself. On July 29, 2025, somebody drove the 2023 Tesla Model Y registered to David to its final parking spot on Bluebird Avenue in the Hollywood Hills. The car sat there for 38 days before parking enforcement issued a citation, and another 3 days after that before it was finally towed. A private investigator named Steve Fisher, who was hired by the owner of the rental home David had been staying in, obtained neighborhood surveillance footage that captured the Tesla arriving at Bluebird Avenue on July 29th. He has handed that footage over to LAPD. He has said on the record that he can identify the person who was driving, and he has declined to name that person publicly, saying he does not want to interfere with the active investigation. July 29th was also the day David and his touring team left Los Angeles for the Withered World Tour. He was not behind the wheel of the Tesla. Someone else moved that car into that spot. Whoever they are, they either knew what was inside the front trunk or they did not. Neither possibility is a comfortable one. That unnamed driver is one of the questions that still has to be answered, but the case is not going to sit still while that happens. With the charges now formally filed, both sides are moving quickly, and there are 4 specific things worth watching in the days and weeks ahead. The first is the defense strategy, and there is one sentence buried in the defense's public statement from April 20 that reveals where they are planning to fight. David's attorney Blair Berk did not say that her client did not kill Celeste Rivas Hernandez. What she said was that David Burke was not the cause of her death. That phrasing is very deliberate. Burke is one of the most experienced defense attorneys in Los Angeles. When an attorney of her caliber picks those specific words, it is not an accident. The defense is leaving itself room to argue that something other than David's actions caused Celeste's death, a position that could open the door to an entirely different theory of what actually happened during those April 23 hours. The second thing to watch is the preliminary hearing. At the arraignment, Burke asked for it within 10 court days. That is a right David has under California law, but almost no defendant in a case of this weight actually uses it. Most defense teams waive the 10-day window because they want more time to prepare. Burke did not waive it. She wants the evidence in the open, in a public courtroom, as fast as possible. That is the move a defense team makes when they believe the evidence does not hold up under pressure. The third thing is the medical examiner's report. Since late 2025, the findings from the autopsy have been sealed by a court order that LAPD had requested. On Monday, Hochman announced that his office would be asking a judge to lift that seal. If that motion is granted, the public will finally learn what the examiner determined about how Celeste died. The fourth thing is the voice of Celeste's family. Her father, Jesus Rivas Hernandez, issued a statement on April 18th through the family's attorney. It was 3 words: justice for Celeste. Under California law, a victim's family has specific rights to be heard throughout a prosecution, at bail hearings, at sentencing, at any plea negotiations. The Rivas family has signaled through their attorney that they intend to be present for every one of those moments. This case is a long way from finished. The next court date is Thursday. The preliminary hearing is coming within days. The medical examiner's report may finally come out. And the name of the second suspect is going to drop. Every one of those moments will be covered here first, so if you want the updates the minute they land, hit subscribe on your way out.